Hi, my name is Kevin LaPorte. I'm an attorney at the LaPorte Law Firm, and today I will be covering how to qualify for SSDI. And before I get into it, I just want to define some terms. So, SSDI just means Social Security Disability Insurance Benefits. This is the federal program. It's commonly referred to as Social Security Disability. There's a lot of different disability programs like state disability, workers' comp with similar terminology, but for today's purposes, we are just covering Social Security Disability and specifically SSDI, Social Security Disability Insurance Benefits. Similar to an insurance policy, Social Security Disability is funded through your FICA taxed earnings. Everybody has a unique monthly Social Security benefit based on your work history and your FICA taxed earnings history. You can find yours out by creating an account at myssa.gov. Now, when anybody applies for Social Security disability, Social Security is going to apply something called the 5-step sequential evaluation. This sequential evaluation applies to every case, and I'll go over that with you today. So, step one of the evaluation is, are you working? So in general, and there's some exceptions, but in general, if you're working and you're grossing over a little bit over $1,600 gross per month, you're not eligible for Social Security disability. This is a benefit for people who are unable to work due to a disability. So step one is Social Security asks, are you working? If so, they will deny your case. That's called a step one denial. And then if not, they will go on to step two of this sequential evaluation. And that is, do you have a severe impairment? Now, a severe impairment is something that causes workplace limitations and has lasted or can be expected to last 12 consecutive months. So in other words, the law requires that you be out of work and disabled at least 12 consecutive months, and that Social Security considers only those conditions that are longer lasting. So that's the 12-month rule. It's often described as the duration rule. So you need 12 months to be eligible for disability. There's some exceptions, but that's the general rule. Now, step two is seen as a easier bar to clear. Most impairments, Social Security will agree, as long as they're long lasting and will impact your ability to work, that Social Security will agree they're severe. So if so, they'll go on to step three, which is, do you have a listing level impairment? So Social Security's listings are their blue book sort of definition of a disability under their rules. There's specific medical criteria that Social Security will look for to determine whether an individual has a listing level impairment. You can look them up online. These are publicly available. And if you search out the different disabilities that are listed in the listings, they have very specific medical criteria. These are viewed by Social Security as pretty high bars to clear in order to have a listing level condition. So if Social Security does not find you have a listing level condition, they go on to step four of the sequential evaluation, and they'll ask, can you do your past relevant work? So in Social Security cases, past relevant work is anything you have done in the last 5 years before you became unable to work. The rule used to be 15 years, but they've changed it to 5. And if Social Security thinks your conditions would not prevent you from doing your past relevant work, they'll issue something called a step 4 denial. They'll say, we think you can go back to work and you're not eligible for this benefit under our rules. You have appeal rights and you have 60 days to file such an appeal. If Social Security agrees that your condition would prevent you from doing the type of work you've done in the last 5 years, they'll go on to step 5 of the sequential evaluation. And they'll ask, could you do something else, maybe something very similar to what you used to do if you're over age 50, or something maybe even easier in the national economy if you're under age 50. And these jobs they're looking at are 8 hours a day, 5 days a week, full-time work. That's sort of the standard. If Social Security agrees you cannot do any kind of work, they have to approve your case under the rules. They'll issue an award notice. If they disagree, if they think there's some kind of job you can do, they'll deny your case, at which time you have a right to file an appeal. It's recommended that you contact an attorney because each case is unique. Everybody has different work backgrounds, work experience, different conditions that would affect their ability to work. There's exceptions to a lot of the rules I've covered today, but these are the general principles in Social Security law, this 5-step sequential evaluation that they apply to every case. We are happy to talk to anybody at any part of this process. If you are still working, but you're anticipating going out of work due to a disability, give us a call. We're happy to talk, happy to discuss this process, the rules, timelines, and just, give you an average current wait time so you know what to expect when you're anticipating going through this process. It can be a bit of a long, time-consuming process, so it's better to know going into it what to expect. And we're happy to discuss your case, the specifics, how your case might fit into Social Security rules and regulations. Thank you for your time today. Thanks for listening, and take care. Bye-bye.